Hello, y'all. Sarah Boone is all smiles today with her ninth attorney representing her. Now, they put in a motion for a continuance, but, well, the judge granted. Judge Cranick did say that he was not going to give another continuance for this trial. He's going to make sure the trial date happens October 7th, unless there is some extraordinary circumstance. So having a new representation, having a new attorney, does that include, is that also part of extraordinary circumstances? Probably not. The judge also reminded us that the trial had been continued 16 times already.
For a 2-week trial period beginning.
Oh, this is what I was listening to. So I was listening to this part and I was like, oh, wait, is Sarah Boone, is she going to get her trial pushed?
All right, sir, I'm going to give you 2 dates. You don't need to memorize these. You'll be given paperwork momentarily. The first date is the date of your pretrial conference. That's where we're going to discuss whether or not your case is ready to proceed to trial. That'll take place on November 22nd at 1:30 in the afternoon. And if your case is ready to proceed to trial, it may be tried during the 2-week trial period beginning December 9th.
Yeah, so I was making breakfast and I had the stream in the background and I heard November and December and I was like, wait, what's going on here? Is the judge granting the continuance? But no, that was for a different case. Disregard, please. Do we know if she's paying him? I don't know how it worked if she was paying him, but then she had JAC cover the fees for experts and other stuff. Oh, this one, I didn't mean to freeze frame it here. It kind of looks like she's giving him the stink face, but I'm just assuming it's pro bono. I think the judge is going to mention it later on that it might be pro bono. But yeah, look at Sarah Boone. She's in a good mood. She's smiling, she's laughing. I don't know if she's smiling and laughing at the attorney or if she's just kind of like smiling and laughing to herself.
Judge, I'm James Owens and I'm representing Sarah Boone.
Sir, good morning. Pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now. Clerk's going to go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive...
It kind of sounds like it's a bit echoey, like we're in a fishbowl or something, but what the judge is saying, so there was supposed to be a digital evidence viewing, which that was already done with Sarah Boone, and I think with prison break investigators, or is it called prison break investigators as well? Her PI that she has, that was already done. And if there were going to be any objections to that, that would have been done on August 23rd. Now, there's also a physical viewing of the viewing of the physical evidence. That was supposed to be done, I guess today. Now, I remember she didn't want the media to be there. She didn't want anyone else that wasn't involved in the case to be there. And the judge initially denied that. But the state was like, hey, we're willing to work with her and maybe we could do the evidence viewing at like a jailhouse or at was it the sheriff's office maybe arrange some sort of thing where she can be transported to the sheriff's office and they can do the physical evidence viewing together.
Foresee such a notice in the court file. Mr. Castore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if, in fact, that viewing took place?
It took place.
Okay, all right.
Oh, good. Okay, so they were able to do it because I know she didn't want to do it in open court. She didn't want us to be there, the media.
Very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right. Thank you very much.
Remember that Sarah Boone, she requested for money set aside to hire a neuropsychologist, and JC was like, didn't seem like they're going to go for it. And also, I think the fees were a lot higher than what JC typically approves of. Now, her defense attorney that she has right now, he's going to be like, we don't need the neuropsychologist.
And appointing neuropsychologists to assist the defendant in preparation of the defense that was filed on 14th.
And she wanted to have the neuropsychologist to attest to, I guess, like the trauma that she endured.
Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist.
So her attorney's like, you know what, my client, I don't think she knew what she was doing, so we're going to abandon that motion. We don't need a neuropsychologist. I want to have some other experts come on.
Dr. Julie Harper, who was on this case previously, I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times.
Oh, yeah. So when Padilla withdrew, I think he withdrew within, was it within weeks before Sarah Boone's trial was supposed to happen?
Haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I met with my client. I think my client meets the criteria for battered spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion.
Okay, I mean, we got our answer. They're going to go for the battered spouse defense, and they're going to use a forensic psychologist that was already working with the previous attorney, was it Mauricio Padilla?
In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
Dr. Michael Berkland. Is this, let's see, additional discovery. We have the forensic psychologist. So the forensic psychologist that they're talking about, this is the motion that he put in. Motion to appoint forensic psychologist comes down to the defendant by and through the undersigned attorney, moves this honorable court for the appointment of due process provider to aid in the preparation of defense in the above style cause and as grounds would show. 1, defendant is charged with second-degree murder and has been previously found indigent. 2, undersigned attorney is privately retained and requests the assistance of a forensic psychologist to aid in the defense of this matter. The defendant is financially unable to hire to due process provider, forensic psychologist to aid in the preparation of the defense, and therefore requires the assistance of court to ensure the protection of her rights to due process and effective assistance of counsel. Didn't JRC already kind of approve? Didn't they already have like an amount that they approve for her to have a expert, like a psychologist? I thought they already did this. Dr. Harper is requesting and has been paid in other court-appointed cases a rate of $200 per hour to perform her duties, including time and spent traveling. The undersigned requests Dr. Julie Harper be appointed a rate of $200 per hour for work and travel time with the initial cap of $7,500 exclusive of necessary costs that allowed by statute. All right, so here is for the crime scene reconstructionist and the death investigator. Comes down to defendant by and through the undersigned attorney moves his honorable court for the appointment of a due process provider to aid in the prep of the defense in the above styled cause and as grounds would show. The undersigned attorney is privately retained, requests assistance of a crime scene reconstructionist / death investigator to assist in the defense. I wonder, a crime scene reconstructionist, I mean, what are they going to reconstruct for us? Are they going to try to say that, hey, look, George got in the suitcase by himself? He zipped it up by himself. My client was so drunk that she was unable to assist him or help him or understand how serious this was. Like, I don't know I don't know. I guess what is a crime scene reconstructionist? What are they going to explain to us? Exclusive of necessary costs allowed by statute. So this is the motion that he said he filed, and the judge is like, oh, I don't see it. Where is that?
I filed these, Judge, yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. Counsel, when I was prepping last night was the motion for statement of particulars. They called on September 2.
Motion for statement of particulars. It's very short. We'll read this really quickly. comes to the defendant by and through the undersigned attorney under Rule 3.140N of the Florida Rules of Criminal Procedure, requests this court to enter an order requiring the state of Florida to furnish the defendant with a statement of particulars concerning the alleged offense, including the following. Should I zoom this in for you guys? I'm sorry, I didn't zoom in earlier. My bad. The person in charge of the information states, charges that Sarah Boone, on or about the 23rd day of February 2020, in said county and state, did in violation of Florida statute 782.042 by an act imminently dangerous to another and evincing a depraved mind regardless of human life, did kill George Torres. Number 3, under the Florida Standard Jury Instructions for Criminal Cases 7.4, murder, second degree, section 782.042, Florida statute. To prove a crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, the victim is dead. He is. 2, the death was caused by the criminal act of the defendant. The jury will decide that. Number 3, there is an unlawful killing of victim, so George, by an act imminently dangerous to another and demonstrating a depraved mind without a regard for human life. The jury will determine that as well. Definition. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do seriously bodily injury to another. Leaving someone in a suitcase. I mean, you would definitely for sure know at a minimum that it would definitely do serious bodily injury to them, especially if they said they couldn't breathe and they wanted to get out. Number 2, is done by ill will, hatred, spite, or evil intent. We saw the video recording. She was definitely very angry with everything that's been happening between the two of them. Number 3, is of such nature that the act itself indicates an indifference to human life. Yep, we have that video recording. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had intent to cause the death. Number 4, Florida Rules of Criminal Procedure. The defendant has a right to know of the charges against them with specificity. Number 5, upon request, the state must provide specificity, you know what I'm trying to say, and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure the defendant's rights are protected. Number 6, the rules require the information on which the defendant is to be tried shall be a plain, concise, definite written statement of the essential facts constituting the offense charge. Number 7, the information fails to inform the defendant of the particulars of the offense sufficiently to be enable the defendant to prepare a defense. Wherefore, the defense would respectfully request the court to reconsider this request and grant the defense motion for statement of particulars. So the judge is like, I have this. I just don't have the motions for the appointment of the expert stuff. Yeah, write down your crimes. Who was that Utah mom again that had a diary documenting all the horrible things that she did to her children? What case was that recently? So the judge didn't have all the motions that were filed with him. It wasn't filed online, I guess, and he wasn't able to view it. The judge is going to have a different hearing set aside where JC can also be in attendance as well to see if they're going to approve of the 2 forensic psychologists and the crime scene reconstructionist / death investigator.
I'll do my best to endeavor to try to get these heard as soon as possible.
Judge, and I have, I filed my notice of appearance on Friday.
Yes, sir.
And I've spoken with Dr. Berkland 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me.
Yeah, and huge applause to the state. So when this attorney, the defense attorney, filed his motion for the appearance, so he was going to, saying that he's going to represent Sarah Boone, the state, I think on the same day, very quickly provided this attorney with a bunch of discovery stuff, and I applauded them for that. Oh, here it is. So notice of appearance.
I provided that to Dr. Berkland. I believe he has the autopsy.
CPS told her the dangers of putting her son in a suitcase the year before. Do you have a citation for that? I've never heard anything about that. Was it like in the family court stuff or something? But that's all sealed.
With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., the state will get the opportunity to review this.
I just reviewed it.
The motion for additional discovery. Okay, so here's the other one that was filed. Number 1, additional discovery. On the showing of materiality, the court may require such other discovery to the parties as justice may require. So let me zoom in. Specifically, the defense is requesting the Office of the State Attorney to provide the written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures. Can't he just obtain it from the Orange County Sheriff's Office himself? In particular, the policy in place at the time of the interrogation. Oh, okay. So this was mentioned. Defense said that he had an issue with the interrogation. So I wonder, what is he going to bring up? Is he going to say that she wasn't? Because I didn't see the entirety of the interrogation. I watched the JCS version of it. Is he going to say that she wasn't properly Mirandized or something, that her rights were violated? Where are we going to go with this? In particular, the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office. Wouldn't this be something that the defense would be able to just research on their own and reach out to the Orange County Sheriff's Office instead? Wherefore, the defense would respectfully request the court consider this request and grant the defense motion for statement of particulars. Okay, so that goes back to the statement of particulars that they mentioned earlier.
Just now, here in court this morning, the state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally in writing, given the...
Now that she has a lawyer that would take her boxes of evidence and laptop away from her, they take away her boxes of evidence and laptop away from her since she's no longer representing herself. I do not know. I don't think that was even addressed, but I mean, I'm assuming she probably doesn't want to do that work anyway. She'd probably just rather have the attorney do all that himself. But, maybe she wants to be really involved in this case and work back and forth with the attorney. But I just feel like it's a lot to view. It's probably really easy to be overwhelmed. What bothers me is no one ever considers George's family, that he had children. He may have had problems, but still didn't deserve. No, I think a lot of people are on the same page as you, Dog Mom. But he still didn't deserve what she did to him. And the fact that she doesn't have any remorse. Yeah, that's why I think a lot of people really fucking hate her. The fact that he was suffering in this suitcase, he was literally being tortured. Because we don't know how long he was in the suitcase for before, he finally succumbed to just suffocating to death.
The lack of time we've had to prepare to make a formal response.
Sure. How much time, Counselor, would you like in order to file a response to the motion for statement of particulars?
I don't know who she's laughing at. But anyways, the judge is trying to figure out when the state is going to respond to the defendant's motion for the statement of particulars and then also the motion for the additional discoveries. The judge gave the state about over a week to respond to those.
The state shall file a response to both the motion for statement of particulars and the motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th.
Oh, wait, hold on. I think I found the article that you're talking about. Let me just see. Deputies, woman accused of leaving boyfriend to die in a suitcase after a game of hide and go seek once posted a photo of child zipped in suitcase on Facebook. Oh boy. Orange County woman accused of leaving her live-in boyfriend zipped inside a suitcase to die after he begged her to let him out following a game of hide and go seek once posted a photo of a child zipped inside a suitcase on social media. Orange County deputies said 4 years ago they investigated the photo of a child in the suitcase that Sarah Boone posted on Facebook and found that there was no harm done. What the fuck? Is this just something that she just does with people? That was investigated 4 years ago. Both our investigators and Department of Children and Families realized that was consensual. The kid wanted to get in there. Yeah, but I wonder whose idea that was. The kid wanted the picture of being in the suitcase. What? Was he fully zipped up though? Because if you're fully zipped up, then you're not going to be... Maybe he wasn't fully zipped up. Because I was like, if you're fully zipped up, you're not going to be able to see that you're actually inside the suitcase. Boone is now being held on no bond on a charge for secret murder, blah, blah, blah. Okay, I don't know. Maybe Sarah Boone just has a thing with suitcases. Fucking weirdo. Sarah Boone's defense attorney wants 2 forensic psychologists on this case. Now, there's a reason why he wants this other one.
I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing the defense. And there's a second doctor, Dr. Michael Brandon. He was the forensic psychologist in the Marcia Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case. So that's...
Are you guys familiar with the Marcia Thompson case? They want to have an expert that was also an expert for Marcia Thompson, and Marcia Thompson was acquitted this year, he said. South Florida woman killed her abusive husband. Does she belong in prison? ? Marcia Thompson, 44-year-old U.S. Customs agent, was the first to admit she shot her husband while he laid unarmed on the living room couch on August 9, 2019. Prosecutors conceded that 4 years of physical and sexual violence predated the shooting. The question for jurors was her state of mind when she killed him. State attorney suggested Marcia Thompson was fed up with the constant abuse she endured at their home in the acreage. Rather than report her husband to the police and file for divorce, the prosecutor said she took matters into her own hands. Terry Thompson should have been prosecuted, not executed. She shot her husband unarmed. Her husband was unarmed about 9 times, 6 times in the back. Damn, 6 times in the back. Florida self-defense law permits the use of lethal force in response to an immediate threat to life, but Walensky maintained that there were none. Terry Thompson laid in his underwear with his feet propped up, his arms upraised to shield himself when his wife shot him 3 times with her service-issued handgun. Wait, what? How did they acquit her of this then? He rolled off the couch, lay face down on the ground. She shot him 6 more times in the back. She knows what imminent danger looks like because she's lived through it, Walensky said, referring to the physical and essay that Marcia Thompson testified to early in the trial. This was not it. Marcia Thompson said that her husband promised to kill her in the minutes leading up to the shooting, but it wasn't enough to say he would do so, Walensky said. The prosecutor urged jurors to consider the difference between a verbal threat to kill and an actual attempt. I want him to pay. Husband to spend life in prison. Oh, sorry, this is a different article. Marcia Thompson's attorney, Jessica Mishali, called upon a forensic psychologist, Michael Brandon. So this is the expert that Sarah Boone's defense wants to testify that a battered woman's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in situations others would not, he said. Ms. Shawley also told jurors not to put too much credence in the fact that Terry Thompson was unharmed. His wife didn't know that at the time, she said. Terry Thompson had a gun in the closet, a golf club in the living room, a machete by the bed, and knives hidden throughout the house, sometimes in between the couch cushions where he lay the morning he died. Crime scene investigators said they found no evidence hidden within Terry Thompson's reach, but he didn't need one to kill his wife, Michelle said. He demonstrated time and again that his hands alone could do the job. Psychologist says abuse victims are at greater risk of violence when they leave the relationship. Marcia Thompson testified that when she met Terry at the University of Florida in 2000, she was 20 years old. They dated for several years. They married, had 2 children. He was 13 older than her, and he was charming. Let's see. So I guess he was the very jealous type who would keep calling her throughout the days. If she missed the calls or she didn't answer his text messages, he would get really angry, paranoid. 2007, he accused his wife of cheating, went through a fit of rage. Interesting. I've never heard about this case. During prosecutors' last opportunity to address jurors, the assistant state attorney, Karen Black, emphasized a premeditated element of first-degree murder charge. Marcia Thompson spent 15 minutes in her room getting ready for work, listening to her husband berate her from the living room, before she rejoined him there and shot him to death. The prosecutor urged jurors to time out those 15 minutes in deliberation room and consider exactly how long Marcia Thompson had to make that decision. Someone's battered spouse syndrome can still commit first-degree murder. That's what she did here. She committed first-degree murder. See, it seems like the victim also had an ex-girlfriend that also described similar abuse as well. The victim punched her hard enough to leave 2 black eyes. He dragged her throughout the home by her hair, chunks of it spooling in the shower drain afterwards. He squeezed her with so much pressure, left bruises. Alienated her from friends, family, colleagues. Interesting. How? Yeah, I don't know. How? Because for me, when I think of, are you guys familiar with the show? What's her name again? Danielle something. The headlines for that case was really bad. She was a woman who married her sort of stepfather. So her mom passed away and she bonded with her stepfather. They married, they had kids, and they were in a very, she was in a very abusive relationship with him. He was stabbed once by her because he was like attacking her and she feared for her life. She grabbed the knife. She stabbed him once. She ran to the bathroom, and the headlines were so bad because she was like supposedly on the dating app, and I think she was just probably really nervous and just like checking her apps and stuff like that. But it was reported that like, oh, woman kills husband and then goes on dating app and then reports the husband dead like 9 hours afterwards. And when she called 911, she told them that he died from a heart attack. But then when they got there, obviously there's a fucking knife in his chest. And I guess she just ended up confessing to everything else. But that one, they did find that she was not guilty. And I did agree with that, even though the headlines look really bad and the circumstance of it seemed pretty bad. But it was like she was under attack. She stabbed him once. She left him. And even though it was really bad that she didn't report him until 9 hours later, that she lied about it, you know, that's a whole other thing. But that one, I was like, okay, I could see why the jury decided to vote not guilty. But for the Marcia Thompson one, I don't know. Maybe I'm missing something. I don't know. If he wasn't like actively like going after her, and then she like shot him while he was like laying on the couch, and then she shot him again like 6 more times in the back. I don't know. But like I said, that was just an article just recapping it. There could be some things that we missed that, maybe if I knew everything, I would agree with the jurors as well. But yeah, what the suitcase thing was the Sarah Boone one. I mean, yeah, he was in the suitcase, he was pleading, and there's a video there. And I think that's going to be really hard for the jurors to ignore that.
It took a while to get to trial. But Doc, first degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brannon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brannon said victims of repeat violence may fear death in situations others would not. And I've tried to reach out to Mr. Brannon this weekend unsuccessfully, and my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brannon, and then the crime scene reconstructionist, Dr. Michael Burton.
I don't know if JC's going to prove that, though. I don't know. We'll see what JC says. So he's requesting for 3 experts, one that has already been hired, who is a forensic psychologist. However, he wants the other forensic psychologist who was able to get this other woman acquitted of first-degree murder, but he hasn't responded yet, so he's waiting for that response. And then, I don't know, we'll see if they're able to get Dr. Michael Brannon on this case. Hi, Billy Lane.
We need evidence to corroborate that, so there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these 2.
I'm sure that, is he saying that maybe like law enforcement and then the state attorney's office, they don't have all that information? Because I'm assuming they probably would have investigated this and then have the information of all the tenants that live in that building and maybe like, interviewed them. Maybe they weren't able to interview all of them, but I guess maybe he wants to like reach out to other people that the state and law enforcement may have missed. Like, yeah, that's going to be hard.
As well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved and their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000.
That's what I was wondering. I was like, JC already had an amount that they approved, so I would expect them to work within that confine. Okay, so let's see what he said. He says, I'm not doing this for attorney's fees. I'm not making any claims for travel costs. He just wants money for the experts.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs since they've already said yes, but file it, and we'll try to tee it up for hearing as well to see if they have any position, or it could just be, the order can be modified to extend to you as counsel for Ms. Boone. That takes us now then to your motion for continuance file. That was...
All right, so here it is for the motion for continuance. So he's saying that like, hey, I just got onto this case. During the time when he filed the motion, he said the trial was going to happen in 38 days. I need more time to prepare, and that in order to file for the battered spouse defense, you have to do it 30 days before trial. And I only have like this little amount of days to file it before that, but I can't file it until I talk to all these experts. So can I get a continuance? And then I was like, well, when I covered in the video, I was like, I don't know if Mr. Michael Kranick, Judge Kranick, I don't know if he's going to give this continuance, because he's already said, I'm not doing the continuance no matter what, unless there's something extraordinary that happens.
Filed on August 30th. Courts had the opportunity to review that motion. Any other argument or statements with regard to that motion? Mr. Robinson.
Judge, I reviewed the state case law relating to continuances and the palpable abuse of discretion when the court does not grant it, but it is critical to our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement, that was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls, and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. Or may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment.
For whatever reason, I mean, you saw the motion to withdraw. Irreconcilable differences.
And then here we are. But
and that the relationship between Padilla and Boone became extremely contentious. I forgot what language Padilla used, but it seems like it was like very contentious to the point, contentious to the point where Padilla was like, I can't represent her. This is, I won't be able to do this in good faith, probably.
I think it's prejudicial if we're not allowed.
Oh, he used the P word, prejudicial.
I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles sometime at the end of the year or first of next year. I can be ready.
So I guess he's asking for a continuance, so like maybe like December, maybe beginning of January, and he's arguing that like, it takes time for you to really develop this battered spouse defense, and that I'm going to have to file this, kind of just give the state a heads up, like, okay, well, what's the defense we're going to go with like 30 days before trial? And he's like, well, I only have a week to do all this, but like I have to get with the previous expert. I'm trying to get this new expert that did really well in this other case, and I don't know if I'm going to have enough time. and I have to get like those medical reports and all that stuff. But it kind of goes both ways because he's saying that like he knows how much time it's going to take to get all of this. At the same time, the court could just be like, okay, well, you knew this. You're admitting it right now that you knew this and you decided to take on this case. And, that's just kind of where you're at, unfortunately. Let's see what the judge says.
God will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take the deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Padilla has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We've tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why.
So he wants to know the policies and procedures of the Orange County Sheriff's Office. Was that what it was? And he's telling us the reason now because he said there was an issue with the interrogation. So I wonder if he's going to try to omit the interrogation video in the jury trial.
I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could. But
Okay. I mean, I feel like the judge is going to take that and be like, okay, you said you think you'll be ready for the October 7th trial? All right, let's do it.
not without the battered. Yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense because I don't believe my experts will be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys, and in fact, the state.
Right. And it's not like this is a new defense that, the other previous attorneys weren't trying to explore and that he's the first defense attorney to explore this. There's been the other work of other previous attorneys that he's piggybacking off of. So he's like, Mr. Cacciatore is saying that like, it's not like he has nothing. It's not like he's starting from the ground up.
They did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't know if you guys were able to hear that, but the state also opposed to the state opposes to the continuance.
I don't think the state's thinking it through, Judge, because if we
I don't think the state's thinking it through. Mr. Cacciatore looking over there. Excuse me, sir, what'd you say?
Potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file the notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired. If the judge doesn't continue it today, he wants to have a conference next week, but it's too late for me.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said it, 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're going to rely on it.
But they've already had a previous expert that worked with her, Dr. Julie Harper, right? Saw Sarah Boone 6 times, was working under Padilla, and then, something happened, Padilla withdrew, something happened. But it seems like they already had an expert that was willing to say that Sarah Boone suffered from battered spouse, being a battered spouse. So I'm a little confused.
putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can follow that in good faith. I can't do it without Dr. Harper. She needs more time.
Oh, Dr. Harper needs more time. Okay, I thought Dr. Harper already decided that Sarah Boone qualifies for being labeled as a battered spouse.
Brandon needs more time.
That's where I'm
All right, thank you. State anything else?
No, you're not.
All right, thank you very much. All right, Mr. Owens, it seems like you've already started diving.
And this is where the judge is just gonna lay it all out. He's gonna remind us the order that he made when he basically took away Sarah Boone's, where he forfeited Sarah Boone's right for representation because she fucked up her own shit. So he's gonna lay it out there all over again. And we recently went over the judge's order again, just as a refresher. But he's gonna kind of give us a little refresher again, and I appreciate that.
The case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yep.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This
She ain't smiling no more.
case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation.
And Laura, was so spot on with this because this is exactly what the Laura, guy was saying, what the judge would probably say to the attorney requesting for the continue. Woo! Spot on.
You undertook this assignment knowing that you were not being appointed, and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking
Yeah, I mean, this is what the judge is saying. You're doing this free of charge on a pro bono basis. And I feel like the judge should know if that's correct or not, and he wouldn't just be saying it if he didn't know, right? Unless the judge is wrong.
Doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020 under Mr. Padilla's representation of Ms. Boone. At no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested.
See, here's the thing. I think in addition to shopping for attorneys that were assigned to her, I think she was also shopping for experts to go along with what she wants for trial. It seems like, I don't know what happened. Maybe her, this is just me speculating, okay? Me completely fucking speculating. Maybe her and Padilla ultimately, maybe their relationship became contentious because she didn't like the experts that was working with them. And she was like, well, why can't you get another expert that can say what I want to say? Maybe, I don't know. Like I said, I'm just speculating here. But it seems like she's already gone through other experts. There was aside from Julie Harper, that was appointed to her and met her 6 times. There was a Charles Heller that was appointed to her. I don't know. Maybe she wasn't happy with, what Dr. Charles Heller was saying. And then Winston Hobson had another expert that met with her. But the judge is saying that this expert did not meet with what Miss Boone had desired. So I don't know if these experts are just saying, like, hey, you don't qualify for blah, 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 blah. And then Boone's like, oh, that you must be wrong. I don't agree with you. So I don't know if she was also shopping for experts as well, hoping to find one that agrees with what she wants him to say.
As addressed in open court on February 9, 2024, and as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February.
Another expert. So we're going through experts. We're going through attorneys.
Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023 again, by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd.
So she met with a lot of experts, a lot of psychologists.
115.
I'm actually surprised that JC went through so many. I don't know. To me, it seems like because there's already been so many other experts that met with her, other psychologists. I don't know. Something tells me that JC is not going to let her hire this other forensic psychologist that they want to have on the case. I don't know. That's what I'm thinking. Maybe not.
52 and 1176, Embargo v. State, 221 Southern 3rd, 562 at 569. There's a 2-part test determining the need of experts. We're not going to be addressing that today, as you've sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here and have the opportunity to review those. In Ramos versus State, 75 Southern 3rd, 1277, at pinpoint 1281, by the Florida 4th DCA in 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date
16 times?
The court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial was counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering
the judge is just reminding her over and over and over and over again what Sarah Boone did in order to screw herself over this badly.
Prejudice of the denial. Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since...
You know what? This is why I really like the judge. I feel like he's really firm, but at the same time, he's like firm, fair, in my opinion. And when he's telling the lawyer no, he's like, hey, let's go over your expertise really quick. And you know what? You got this. You got this. It's like a really soft way of saying no, but at the same time, firm. I don't know how to describe it. But just listen to the part where he basically compliments the attorney here.
Trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986. With a duly elected public defender of the First Judicial Circuit in the state of Florida from 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. In considering all the factors as set forth in terms of the state 311 sub 3rd 185 at pinpoint 189, Florida 2nd DCA 2020, your motion for continuance is denied. Matter of this trial is still set for October.
I don't know. What are your guys' thoughts about that? It's like, although you're not a court-appointed attorney, I've done my research on you, and you've been an attorney since 86. You were a public defender. You won the election for, 2009, 2012 period. And, you met with Sarah Boone a couple times. You got this. You have a couple days to file this, but don't worry, you got this. You've had hundreds of hours working as an attorney. So I don't know. I feel like it's like, okay, I know, right? Barred sounds negative. Yeah, I know. Initially when the judge said that, I was like, barred. That sounds like, because most people, when you say like, oh, someone was barred, yeah, it doesn't sound very good. But I think he meant like you passed the bar, maybe, and then, yeah.
Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
26?
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County before Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covering it, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
Oh, I wonder how Sarah Boone feels about that. Wait, what? I hired you and you have other clients? Excuse me? You're going to appear by Zoom?
Sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings.
Judge,
no problem.
That pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to intend to introduce at trial. That has not happened.
So this is the part where I don't know if he was confused or maybe I was confused, but they talked about that in the beginning of this hearing where the digital evidence was given to Sarah Boone, prison break, Mr. Billy Lane, help with that as well, where they gave her like a USB and then like she was able to view all that. I don't know if he's thinking about the physical evidence viewing where they go through it with the state together.
I went to the jail yesterday. I had let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be.
I like judges like that, where they don't need to be rude, they don't need to be snarky to get their point across. Unlike some other judges. Some other rude judges. Although, sometimes you see a little bit of snark from judges is kind of entertaining from, us viewer perspectives. But I do feel bad for attorneys sometimes when they have to deal with a judge that's like very snarky and rude.
Through the digital evidence as to what I assume it's being redacted. I know some of the audio in terms of clients, comments the client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
I'm not certain, is he asking for a continuance again? What is the extra time that he's he's seeking.
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with the station. They never viewed it with my client in its entirety. As the order states, they were to do by today.
Yeah, this is where I was confused too, because I was like, the digital stuff that was already given by USB, and the physical already happened this past weekend, like Cacciatore said.
So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
Mr. Cacciatore, excuse me, George. This guy has thrown daggers at me 3 times already today. I'm just over here being nice.
On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations. By and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file with the court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail, including the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m., a hearing will be held, courtroom 12A.
Hope they do a reenactment of a person willingly getting to a suitcase and attempting to get out without assistance in the courtroom. I don't know. They want to hire the accident reconstructionist or something? Crime scene reconstructionist and a death investigator. I don't know. That'll be very interesting to hear from in the trial. If they're able to get this person.
A, regarding defendant's review of USB jump drive, which contains the state's digital evidence, the defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024, the pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yeah, and I think this judge is also very patient and helpful too, because the state's like, so I don't know what the defense is asking. Is he asking for another continuance? Because I don't know what he's asking. And then the defense is like, well, I don't know. I don't have, I feel like this should have happened. The state didn't do this. And the judge is like, okay, so what are you asking for? Let me go over this and let me help you out, because I think what you're asking for is to extend the deadline for the objections. Yes, is that what you want?
Yes.
Okay. State?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
Well, I've got to go buy a jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue maybe a week prior to trial. Whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
I'm amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right.
The Hateful Eight, isn't that a movie with Quentin Tarantino? Or is that a different movie title? I watched it recently. That was pretty good. Oh, you know what I watched recently too? The Godfather. Dude, Godfather 1 and Godfather 2. Fredo, why? Why did you do that? Okay, anyways. All these like classic movies I'm like starting to watch now.
We're going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties having no other business before the court. Y'all can have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
Was that a little fist bump? That was kind of cute. I think he gave her a little fist bump, or he gave her something. I don't know what that was. It was for the PI, right? Okay. Listen, we may not like Sarah Boone, okay? I certainly do not like Sarah Boone, but I am for sure glad that she had an attorney because, you know, this hearing could have been 3 hours long, all right? There could have been a lot of back and forth and a lot of the judge re-explaining things over and over and over and over to Sarah Boone, being repetitive to her because, you know, of how she is. I'm just glad that she has an attorney, all right? Now maybe the trial will be 2 weeks long instead of 3 weeks long. You guys talked about the attorney did an interview, and I have it up here somewhere. But you know what? I learned a lot of information, or maybe we had a lot of good refreshers from today's hearing. Just to highlight today's hearing, for those of you guys who missed it, I certainly would probably go back and rewatch it if you guys want to. But just to highlight today's hearing, what do we have today? So Sarah Boone has a new attorney number 9, Mr. James Owens. Mr. James Owens. So today there was supposed to be a physical evidence viewing in open court. That didn't happen. Of course, Sarah Boone is happy that didn't happen because she didn't want the media to be there because her and the state and I think maybe prison break investigators, Mr. Bidley Lane, they met on Friday to do that. So we're not going to do that today. That's good. Sarah Boone, remember when she put in a motion for to hire an expert for a neuropsychologist? Well, her new attorney is like, no, we're abandoning that. We don't need that motion. Instead, we're going to go with 2 forensic psychologists. One of the forensic psychologists was able to testify in a different trial that happened early this year where same thing. Not same thing. I think the circumstances are pretty different, but the woman shot her husband 9 times total, 6 of those times, I think, into his back. And she was acquitted of first-degree murder. I read the recap of that, and I still don't understand how the acquittal happened. But like I said, if I really look into the case, maybe I would agree with the jury. I didn't really do that on stream. So they want to hire that expert to be on this case. But the thing is, the defense attorney reached out to that expert. The expert hasn't replied back yet. I mean, it is Labor Day weekend, but we don't know if he's going to be able to get that expert because one, JAC has to approve of this expert and they have to, I don't know, hopefully get this expert to reply and work with them and meet with Sarah Boone ASAP. Cause that's going to take some time. Not only that, Mr. Defense Attorney also wants to hire a crime scene reconstructionist, a death investigator. Name is Dr. Michael Birkin. And if they do get that, that'll be very interesting because I do want to see what are they going to present during the trial. They talked about other motions that he filed. We went over them throughout this video, so feel free to rewind and go back to those. And if you guys want to watch the live stream, usually what I'll do is I'll edit a video where I have the chapters labeled and you guys can go through that later on if you like. That might make it easier for you. All right, so they're going to try to get some information on the DV arrests on George, try to get some body cam footages from those arrests and those police encounters that happened, 4 plus 5, 6, 7 years ago. It says that the attorney, it seems like the attorney is pro bono. It seems like the attorney is not asking for any fees, not asking for a travel cost, but they just want fees for these experts. Then they address the motion for a continuance. The judge has denied that. I would definitely rewind back to where the judge addressed the reason why he's denying it. And he goes over Sarah Boone's history. And he essentially said that, hey, you weren't appointed by the court. You undertook this. You knew that you weren't appointed. And you knew that you're doing this free of charge on a pro bono basis. You're not asking for compensation on lodging or travel. And when you took on this case, you knew the deadlines for this court. There were other multiple experts that worked on this, and it seems like Sarah Boone was maybe shopping for experts, and maybe she didn't like those other experts, but she had a Julie Harper that was appointed to her by the previous attorney. Oh, well, we also learned, not the previous attorney, sorry, the first attorney that withdrew. The first attorney withdrew about days or weeks before the trial was going to happen. Crazy. I don't know if I realized that. Maybe I did know that and I just forgot. However, they had another forensic psychologist that was appointed to Sarah Boone. I guess maybe that didn't work out, or I'm not too sure. Winston Hobson, a former attorney, also had another expert that met with Sarah Boone, but the judge said this verbatim. The expert did not meet with what Sarah Boone desired or requested of that expert. So maybe the expert made some sort of conclusion and Sarah Boone's like, no, I don't agree with you. You're wrong. There was another expert that was hired by Patricia Cashman. It seems like that expert, I don't know, I guess maybe didn't work out, not too sure, or they dropped that expert because, now there's a new attorney representing the case, or not, that was when she was dropped and then Sarah Boone had to go pro se. There was a Lyndon Durer, I'm not too sure how to pronounce that last name, that Bankowitz hired as well, that specialized in battered spouse, and then was also used by Winston Hobson. So I don't know if they didn't like that expert, but that's a lot of experts to be cycling through. The judge also made a point to mention that the case has been continued 16 times already, and that when he set that on June 7th, when he set that trial date for October 7th, he's keeping it. He's not going to move it for whatever reason, and we're going to have the trial in about a little bit over a month. So he also reiterated that Sarah Boone played a prominent role in shortening the prep time, how Cashman withdrew, how Sarah Boone had 4 attorneys that were not conflicted out. So, all this stuff that's happening to her right now is because of her own doing. And again, like I said, the judge, I think he does a really good job. Like when he's saying no and being really firm with it, he's also kind of complimentary as well. Because he reminds the defense attorney, like, hey, like you are really you're a well-seasoned attorney. Okay, you've been doing this since 1986. You were elected as a public defender, like the public defender from 2009, 2012, and you got this. You have time to file this. You got this. They did set a pre-trial date of September 26th at 9 a.m. So that's going to be a Thursday. So about 3.5 weeks away from now on a Thursday. He's letting the defense attorney to appear by Zoom, just as long as he gives a court notice, which is fine. And yeah, I think that's about it. And then, he did extend the deadline. So if this new attorney wants to make any objections to the evidence, they did extend that deadline out to, I think, a week before trial. So that is a recap of today's case. And I feel like we learned some stuff here, or, had a refresh on things that I may have forgotten. But the overall grand scheme of this is there will be no continuance at all. Oh, go to the end, watch her leave. Did I not go to the end? Oh, my bad. I usually try to go to the end. Did I not do that? There you go. Yeah, she looks happy. She's in a good mood. She giddy. Say bye to her attorney. Thanks for representing me. All right, there we go. Goodbye, Ms. Boone.